Next one. Next discussion is your Article 1789. Okay. In your Article 1789, it states that an industrial partner cannot engage in business for himself unless the partnership expressly permit him to do so. And if he should do so, the capitalist partner may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision with a right to damages in either case. So, we are talking here about the prohibition against engaging in business in this Article 1789. Lagi niyong tandaan na ang isang industrial partner. Okay? What is an industrial partner? An industrial partner is one who contributes his industry, labor, or services to the partnership. Ang isang industrial partner po ay considered the owner of his own services, which is his contribution to the common fund. So, ang isang industrial partner po, okay, there is a physical presence dun mismo sa partnership. Actively participating siya sa day-to-day operation ng partnership. Why? Bakit? Okay? Because the contribution of an industrial partner is his own industry, service, or his labor. So the rule is, this is the rule. Unless the contrary is stipulated, an industrial partner becomes a debtor of the partnership for his work or services from the moment the partnership relation begins. In effect, the partnership acquires an exclusive right to avail itself of his industry. So consequently, if he engages in business for himself, such act is considered prejudicial to the interest of the other partner. Anong ibig sabihin nito? Okay? Sabi ko nga sa inyo, ang isang industrial partner, ang contribution niya sa isang partnership ay yung sarili niyang mismo. When we say sarili niya mismo, yung labor niya, yung services niya, yung industry niya. Okay? So, para siyang empleyado sa isang partnership. So, siya mismo ang hands-on na nagtatrabaho para sa partnership. So, once na nag-engage siya ng ibang business, okay, other than yung partnership, such engagement sa ibang business, pag pumasok siya sa ibang business, that is prejudicial. Big sabihin, damaging yan sa interest ng partnership. Again, what is the reason? Because the industrial partner is hands-on to the operations of the partnership because his contribution is his work, his labor, or his services. So remember, okay, that an action for a specific performance to compel the partner to perform the promised work or service is not available as a remedy. Bakit? What is the reason bakit hindi allowed ang specific performance? Because that will be considered involuntary servitude. Okay? Lagi niyong tandaan that you cannot force a person to work. Okay? That will be a violation of your Article 3, Section 18, Paragraph 2 of the 1987 Constitution. One of the stated rights in the Bill of Rights, your Article 3. Okay? That is involuntary servitude. Bawal pilitin ang taong ayaw magtrabaho. So, how about the prohibition against engaging in business? Okay. I already discussed to you that an industrial partner, the prohibition is absolute with regards to industrial partner. Okay? So the prohibition is absolute and applies whether the industrial partner is to engage in the same business in which the partnership is engaged or in any kind of business. It is clear that the reason for the prohibition exists in both cases. And what is that? That is to prevent any conflict of interest. Okay? Paano naman sa mga capitalist partner, ma'am? Okay? The prohibition extends only to any operation which is of the same business in which the partnership is engaged. Okay? So, kung capitalist partner ka, pwede ka ba mag-engage sa other business? Okay, the answer there is yes. However, it must be of different nature with the business you are engaged already. Okay? Hindi pwedeng pareho because if that will be it will be the same operation, the same nature, it is prohibited. Next is your Article 1790. In your Article 1790, it says that unless there is a stipulation to the contrary, the partners shall contribute equal shares to the capital of the partnership. So, this Article 1790 talks about the extent of contribution to the capital, to the partnership capital. Okay, under this article, the partners can stipulate the contributions of unequal shares to the common fund. Pwede pala yun, ma'am. Yes, okay? Hindi kailangan 20, 20, 20, 20, 20, a total of 100%. Hindi kailangan na ganon. Pwedeng 45, 15, 15, okay? Na yun. 40, let's just say, 30, 20, 20, 30. Okay? So, basta ang total niyan is 100%. Yung common fund. Okay? Pwedeng unequal shares. They can stipulate that. So, but remember, pag walang stipulation, in the absence of any stipulation, the presumption is that their common fund or their contribution shall be in equal shares. So, kung wala silang usapan kung magkano, it should be, okay, it shall be equal shares. This principle is just and reasonable, okay, and is consistent with the rule that partners are deemed to have equal rights and obligations. Next one is your Article 1791. In your Article 1791 naman, okay, it says that if there is no agreement to the contrary, in case of imminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital, except an industrial partner, to save the venture, shall be obliged to sell his interest to the other partners. Ang Article 1791 po, okay, it talks about the obligation of a capital partner to contribute additional capital. Ang Article 1791, okay, it nire-require ang isang capital partner na mag-contribute pa. Okay? May additional contribution. Kasali bang industrial partner? Hindi. Okay? It exempts the industrial partner. So, ang Article 1791, ang may obligasyon lang dito ay isang capital partner or capitalist partner. Okay? At ano ang obligation nila? That is to contribute additional capital. There are, however, requisites to apply your Article 1791. Okay, there are 4 requisites. Okay, the following are the requisites for application of the rule. Okay, the following are number 1. Okay, so this pala is, ang mangyayari pala is, kung hindi si Ana, isang partner ng ABC Corporation, okay, kailangan nilang mag-contribute ng additional capital because there is an imminent loss, okay, in their partnership. Si Ana, ayaw niyang mag-contribute, okay? Hindi siya makapag-contribute. In this case, Ana will be obliged. She will be required to sell the interest, her interest to others. Okay? But before this will apply, okay, this rule will apply, the following requisites should be present. Number 1, dapat meron talagang imminent loss. Okay? Kung hindi imminent yung loss, okay, this rule will not apply. Hindi pwedeng ibenta yung share ni Ana sa iba. The loss must be imminent. Okay, number 2, the majority of the capitalist partner are of the opinion that an additional contribution to the common fund would save the business. Okay, and number 3, the capitalist partner refuses deliberately to contribute an additional share to the capital. So, dapat ayaw talaga ni Ana mag-contribute. Pero kung ang rason ni Ana is hindi siya capable financially, Ana is financially incapable only to contribute, okay, that is not a valid ground. Okay, there must be a deliberate intent or deliberate refusal to not contribute. Okay, and last one, there is no agreement that even in case of imminent loss of the business, the partners are not obliged to contribute. Okay, lagi niyong tandaan in your Article 1791 na exempted po ang isang industrial partner. Okay, because he can do nothing further. Wala pong magagawa ang industrial partner. Kasi sabi ko nga sa inyo, ang industrial partner, ang contribution niya ay ang kanyang industry. Okay. With regards to your Article 1792 naman. Your Article 1792, it talks about, or it says that if a partner authorized to manage collects a demandable sum, if a partner authorized to manage collects a demandable sum which was owed to him in his own name from a person who owes the partnership another sum also demandable, the sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may have given a receipt for his own credit only. But should he have given it for the account of the partnership, the amount shall be fully applied to the partnership. Okay, the provision in your Article 1792 are understood to be without prejudice to the right granted to the debtor by Article 1252. But only if the personal credit of the partner should be more onerous to him. Paano ba i-apply yung Article 1792? Okay? Lagi niyong tandaan na sa Article 1792 may tatlong requisites yan. Ang Article 1792 kasi, it talks about utang or debt. Okay? Utang. Ang utang sa partnership at utang sa partner. Okay. Example, si Pedro, may utang siya kay Ana. Si Ana is a partner of ABC Corporation. Okay? Example, the following, lagi niyong tandaan muna that there are 3 requisites to apply yung Article 1792. What are the 3 requisites? Number 1, merong dalawang utang. Or, there exists at least 2 debts. At least 2 debts. So, pwedeng 3, pwedeng 4, pwedeng 5. So, at least 2 debts. Isang utang sa collecting partner at isang utang sa partnership. Okay? Number 2, yung parehong utang ay demandable. Okay? And number 3, the partner who collects is authorized to manage and actually managing the partnership. Lagi niyong tandaan in your Article 1792, the partner must be authorized to collect and to manage the partnership. So for example, Anna and Ben are partners in XXX Corporation. Okay, si Anna at si Ben ay partner po sa XXX Corporation. Si Anna ang managing partner. Si Pedro ay nagkautang kay Ana ng 2,000 pesos. Si Pedro rin ay nakautang sa partnership in the amount of 4,000 pesos. So, ang utang ni Pedro kay Ana, 2,000. Ang utang ni Pedro sa partnership, XXX partnership ay 4,000. Yung parehong utang ay demandable. Si Ana ngayon ay nakakolekta ng 1,500 kay Pedro. Okay? So, paano natin i-apply ang Article 1792? Okay. This is the rule. Kung si Ana, nag-issue siya ng resibo, okay, kay Pedro. If Ana issues a receipt to the effect that it is in payment of Ana's credit, okay? So, si Ana nag-issue siya ng resibo, okay, to her credit, okay? Yung 500 will be applied only. 500 will be applied only to her credit. Pero yung 1,000, it will be the credit of the partnership. The partnership being entitled to a proportionate amount of 1,000 in payment made by Pedro. Okay? This is the rule kung yung managing partner nag-issue siya ng resibo in his or in her name. Okay? Chinarge niya sa pangalan niya. Pero kung si Ana, na ang nilagay niya sa resibo, it will be for the credit of the partnership. Okay? Yung buong 1,500 will be fully applied to the partnership. Okay? Lagi niyong tandaan na isa sa obligations ng partners ay basta with regards to collection of money, laging unahin yung partnership. Kung inuna nila yung sarili nila, the rule on proportion, okay, will be applied. Paano, ma'am, if yung partner is hindi po siya isang authorized partner to collect? Okay? Paano kung yung partner si Ben? Si Ben hindi naman po siya yung managing partner. Okay? Lagi niyong tandaan na yung Article 1792, hindi po yun mag-a-apply if the partner na nag-collect is not authorized to manage. So, okay, why? Bakit hindi mag-a-apply sa isang regular na partner? Hindi isang managing partner. Hindi isang collecting partner. Okay? Because there is no ground for suspicion. Okay? There is no ground for suspicion that he may have acted improperly to create an undue advantage to himself. Next one is your Article 1793. In your Article 1793, it says that a partner who has received in whole or in part his share of a partnership when the other partners have not collected theirs shall be obliged, if the debtor should thereafter becomes insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only. Ang Article 1793 naman, it talks about the obligation ng isang partner na naka-receive ng pera, na-receive niya yung share niya sa partnership. Pero yung ibang partners, hindi nila na-receive yung share nila. So, for example, si Anna, si Ben, at si Chris, they are partners with XXX partnership. Si Anna, na-receive niya yung share niya. Pero si Ben at si Chris, hindi naka-receive ng share nila. So, how are we going to apply your Article 1793? There are 3 requisites. Okay? Number 1, a partner has received in whole or in part her share of the partnership credit. In the given situation, si Anna na-receive niya yung kanyang share. Number 2, the other partners have not collected their shares. So, si Ben at si Chris, hindi po nila na-collect yung share nila. Number 3, the partnership debtor has become insolvent. Okay, let's just say it is Pedro. Pedro is a debtor of the partnership. Si Pedro, naging insolvent na siya. Walang-wala na siyang pera. Okay? So, in this case, even if Anna had given a receipt for her share only, okay, he shall be required to share the said amount to Ben and Chris. Okay? Bakit pala merong obligasyon si Anna to return the said amount? Okay? The Supreme Court said that the debt of Pedro is considered a bad debt. Okay? Bad debt na siya. So, it would be unjust or unfair for Anna not to share in the loss of Ben and Chris. So, dapat daw pong mag-share din. May share din po si Anna sa losses. Okay? Otherwise, it will be unduly prejudice the interest of the other partners. Okay? Itong provision, your Article 1793, is based on the community of interest among the partners, which is, okay, one of the underlying principles of the contract of partnership. Next is your Article 1795. Your Article 1795, it says that every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen this responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. So, yung Article 1794 nyo po, it talks about the obligation of partner for damages sa partnership. Okay? The Article 1794, it follows the general rule, okay, applicable to all contracts. And what is that rule? Okay, the rule is that any person guilty of negligence or fault in the fulfillment of his obligation shall be liable for damages. This is provided in your Article 1170 of your new Civil Code. So, the partner's fault must be determined in accordance with the nature of the obligation and the circumstance of the person, the time, and the place. Sa Article 1794 po, it likewise talk about the compensation of damages with profits earned for partnership by guilty partner. So, the rule is damages are not generally subject to set off. Okay? As a general rule, the damages na caused by a guilty partner to the partnership cannot be offset by the profits or benefits which he may have earned for the partnership by his industry. Okay? Lagi niyong tandaan, example, ABC Corporation. It is comprised by Anna, Ben, and Chris. Anna, Ben, and Chris are the partners. Here, Anna has let's just say Anna is the guilty partner. Okay? Si Anna has the obligation to secure benefits for the partnership. So, yung profits which Anna may have earned pertain as a matter of law or right, okay, to the partnership, okay, it cannot be offset by the damages she incurred. Si Anna, she has also the obligation to exercise diligence of a good father of a family in the performance of her obligation as a partner. Okay, lagi niyong tandaan yun, hindi po pwedeng i-offset yung profit sa damages. Is there an exception? Yes, it's stated itself in the Article 1794. Okay? Sabi dito, kung nagkaroon ng unusual profits, okay? If there is an unusual profits realized through the extraordinary effort of Anna, okay? Yung court po, they can equitably mitigate, pwede nilang bawasan. They can lessen the liability of the guilty partner. Next one is your Article 1795. In your Article 1795, it states that the risk of specific and determinate things which are not fungible contributed to the partnership so that only their use and fruits may be for the common benefit shall be borne by the partner who owns them. If the things contributed are fungible or cannot be kept without deteriorating, or if they were contributed to be sold, the risk shall be borne by the partnership. In the absence of stipulation, the risk of things brought and appraised in the inventory shall also be borne by the partnership, and in such case, the claim shall be limited to the value of which they were appraised. Your Article 1795, it talks about the risk of loss of things contributed. So, under your 1795, there are 5 cases contemplated, okay, for the determination of the risk of things contributed to the partnership. So, this usually talks about the property na na-contribute doon. 'Di ba kasi money, property, or industry? Ano lang ba yung nasisira? It's always the property. So, number 1. There are 5 cases here. The first case is with regards to specific and determinate things which are not fungible where the only use is contributed. In such case, the risk of loss is borne by the partner. Why? Because he remains the owner of the thing. Example is mga sasakyan. Ang sasakyan po, let's just say Toyota Fortuner or a pick-up. Okay? Yung pick-up laging ginagamit pag magta-travel sila or kukunin yung mga materials for their business. Okay? The pick-up or yung car is pwede siyang masira at any time and wear and tear siya. So, napupudpud yung gulong, yung oil niya medyo nasisira, nagko-consume siya ng gas, at tapos pwedeng nagagasgasan. Okay? So, syempre yung odometer pa nito is nadadagdagan. So, it's always, it can deteriorate, pero it's not fungible. Okay? With regards naman po sa specific and determinate things, the ownership of which is transferred to the partnership. Okay? Here, the risk of loss is for the account of the partnership. Bakit po? Kasi partnership here is the owner. Okay? Number 3. Okay? Number 3 is your fungible things. Okay? Fungible things which cannot be kept without deteriorating even if they contributed only for the use of the partnership. When we say fungible po, these fungible things, ano yung fungible things? Fungible things are those that are capable or that are consumable. Okay? So, pag yung bagay na i-contribute daw sa property, ay sa partnership, I should say, is consumable or fungible. Okay? Kanino yung loss? The risk of loss is borne by whom? By the partnership. Okay? Bakit po? For the risk of loss is borne by the partnership for evidently the ownership was being transferred. Okay? Since use is impossible without the things. Example po nito, okay? Yung mga oil, yung mga wine, yung mga gasoline. Okay? Here, it is consumable and capable of being impaired. Okay? Next one, number 4, things contributed to be sold. Here, the partnership also bears the risk of loss. Okay? For there cannot be any doubt that the partnership was intended to be the owner. Otherwise, the partnership could not affect the sale. Example is if the partnership is engaged in bread company, pagbebenta ng bread. Of course, yung binebentang bread, okay, that is a thing contributed to be sold. Example, yung mga harina, okay? So, the owner there is the partnership itself, okay? And the thing is contributed to be sold. So, yun. Okay, next one. Things brought and appraised in the inventory. Here, yung partnership also bears the risk of loss because the intention of the parties was to contribute to the partnership. Okay, the price of the things contributed with an appraisal in the inventory. So, ibig sabihin yan, okay, there is thus an implied sale making the partnership owner of the said things, the price being represented by their appraised value.